Servitudes. Easement is a non-possessory property interest that confers a right of use to another's land. A servient estate is a burdened land, and a dominant estate is benefited land, not always applicable. Types of easements are easement appurtenant. This entitles a dominant estate owner to use the servient's estate land. So this attaches to the dominant estate and passes automatically, even if not mentioned in conveyance. Easement in gross entitles an individual or entity, not always a dominant landowner, to use the servient estate. So this attaches only to the servient estate. There is no dominant estate. So an example is a right to place a billboard on another's lot, a right to run a utility line across the land, a right to fish in another's pond. This is similar to a license but irrevocable, and it may be transferable. Then there's affirmative easement. This entitles its holder to make affirmative use of the servient estate. Then there's negative easement, which entitles its holder to restrict the servient estate from otherwise permissible activities. Then there's the creation, which easements may be created by prescription, implication, necessity, or expressly by grant or reservation. Then there's the scope of easements. An easement scope is determined by the terms or conditions that created it. In interpreting an easement scope, courts will consider the reasonable intent of the original parties. Expansion. Easement holders cannot unilaterally expand the scope of their easement through overuse or misuse. Overuse or misuse of an easement does not terminate the easement. Remedy for violation is injunction or damages. There's a duty to repair. So an easement holder has a duty to make repairs if he is the sole user. If both the servient landowner and the easement holder use an easement, the repair costs are apportioned. Easements may be expressly created by grant or reservation. So a grant is an express grant of the easement is created by an instrument within the agreement in which the servient estate owner gives easement to owner of dominant estate. So the reservation is the grantor conveys title to the land but reserves the right to continue using the land for a design purpose. The grantor may only reserve an easement for himself. This is void if reserved for the benefit of another. For example, O conveys property to A, reserving an easement allowing access to a path across the property. The requirements are: express easement must, 1, be in writing, otherwise it will violate the statute of frauds, and 2, be signed by the servient estate holder. Easement by prescription is a process acquiring an easement, similar to acquiring title by adverse possession. The requirements are that the acquirer's use of another land must be 1, continuous for the applicable statutory period, 2, open and notorious, so the owner knows or should know of use, 3, actual, 4, hostile, which is without the owner's permission. Note, an easement can also be terminated by prescription if the servient landowner interferes with the easement's sufficiency to satisfy those requirements. Then there's easement by implication. So an easement legally implied based on prior use by a common grantor on land subsequently divided into multiple plots. So the requirements are: 1, that the easement exists prior to the division of a single tract of land; 2, that the common grantor's use is continuous and apparent; 3, the use is reasonably necessary for enjoyment of the dominant tenement; and 4, parties intended the use to continue after the division of the land. Exceptions are that easement may be implied without prior use, where A, there's a subdivision plat, which is lots in a subdivision are sold with reference to a map plan; or B, profit appurtenant, which is where the holder of a profit appurtenant has implied easement to pass over the land surface as reasonably necessary to extract materials such as wood or coal. And then there's easement by necessity. So this is when an easement can arise if access to or from a property is impossible without the easement. For example, the easement's existence becomes necessary. Creation usually arises when a landowner sells a portion of her property and the resulting division deprives one lot owner of access to a public road or utility. The owner of the Servient estate can choose a reasonable location for the easement. Then there's termination. This expires automatically when the necessity ends. Then there's negative easements. So this entitles the holder to prevent the servient landowner from engaging in otherwise permissible actions on his own land. 4 categories of acts may be prevented, which is light, air, subadjacent or lateral support, and 4, a stream of water from an artificial flow. So creation can only be created by express grant, which is writing signed by the grantor. Note, restrictive covenants are utilized more frequently than negative easements to prevent a landowner from engaging in certain activities on their land. Termination of easements. Easements may be terminated in any one of the following ways. 1, Estoppel, where a servient owner reasonably relies on an easement holder's conduct or representations indicating an intent to abandon the easement. Non-use is insufficient. 2, necessity ends. Easement by necessity expires when the need that created them ends. 3, destruction of servient tenements, unless destruction results from willful conduct of the servient owner. 4, release. Easement holder can terminate the estate by giving a deed of release to the servient tenement owner. 5, abandonment. Easement is terminated if its holder physically demonstrates an intent to permanently abandon it. Mere words or non-use are insufficient. 6, merger. Easement terminates automatically if one person acquires title of both the easement and the servient land. Redividing the merged title will not revive the easement. 7, prescription. Servient owner may extinguish an easement by interfering with it using elements of adverse possession. 8, expiration. If easement was established for a set term or to expire upon stated conditions, expiration of the term or occurrence of the stated condition will terminate easement. License, a right to use another person's licensor's land, which is revocable at the licensor's will. An example is oral permission for a neighbor to use licensor's pool. Theater tickets grant a license to ticket holders right to use a parking lot. Not an interest in land. License is a privilege, not an interest in land. This is distinguished from affirmative easement. Revocable. Licensor may revoke the privilege at any time unless estoppel applies. Inalienable. May not be assigned or transferred. Any attempt to do so revokes the licensee. No statute of frauds requirement. A license may be oral or written. They can result from easements that are invalid under the statute of frauds. An oral grant of a permanent easement between neighbors may result in a licensee because statute of fraud is not satisfied. Profit. A non-possessory property interest entitling its holders to enter a servant estate to remove resources such as mineral, timber, soil, or fish. All rules governing easement apply to profits such as creation, transferability, and termination. Extinguishment. A profit may be extinguished through misuse or overuse of resources on the servant's estate. Covenants. A promise to do so or refrain from doing something related to land. A contractual limitation or promise regarding land. Note, covenants are not property interests. Real covenant. A covenant concerning real property runs with the land at law. Subsequent owners may be burdened by the covenant or may enforce it. Different requirements apply for burdens and benefits running with the land. Affirmative covenant is a promise to do something related to the land, whereas restrictive covenant is a promise to refrain from doing something related to the land. Termination can occur by A, written release, B, merger of benefited and burdened estates, or C, condemnation of burdened party. Covenants versus equitable servitudes. Difference is the remedy. Covenants is monetary damages, and equitable servitude is injunction. Requirements for burdens of covenant to run with the land. A successor in interest to the burden estate will be bound by a covenant if the following requirements are satisfied. 1, a writing, so the original covenant was in writing. 2, intent, parties intended to bind succession. Successors and interests, look at the language of the covenant, so courts are liberal in construing requisite intent. 3, touches and concerns the land. Covenant must affect parties' legal relation as landholders. A very low standard. Homeowners association fees satisfy this requirement. 4, horizontal and vertical privity must exist between interested parties. Horizontal privity, relationship between the conveying parties, grantor, grantee, landlord, tenant, fee, ownership, easement, right in the same land, mortgager, mortgagee. Vertical privity is relationship between covenanting parties and their successors and interests, such as contract, devisee, descent. And then 5, notice. Successors in intent had notice of the covenant when she took her interests. So the requirements for benefit of covenant to run with the land is successor in interest to the benefiting estate may enforce the covenant if the following requirements are satisfied. 1, writing. Original covenant was in writing. 2, intent. Original parties intended the benefit to run with the land. Look for language of the covenant. Courts are liberal in construing the requisite intent. 3, touches and concerning the land. The covenant must affect the parties' legal relations as landowners, a very low standard. And then vertical privity. Successors and interests are in vertical privity with the original covenanting parties through contract, devisee, or descent. Horizontal privity is not required for majority of states. Then there's equitable servitude. Equitable servitudes are covenants enforced in equity against successors through injunctive relief. Injunction is the remedy. For example, a covenant that will be enforced against successors of the burdened land who have notice of the covenant. Privity is not required to bind successors. Creation. Requirements are one, a writing, so a written promise. Exception is reciprocal. Negative servitudes may be implied from a common scheme for development of a residential subdivision. 2, intent, so original parties must intend to bind successors. 3, touches and concerns the land. 4, notice, successors of the burdened land had notice, and notice not required for benefit to run. Defenses to enforcement are that a court will not enforce an equitable servitude if only one of the following conditions exists. 1, pervasive changes in the neighborhood. 2, estoppel. 3, acquiescence. 4, unclean hands. And 5, laches. Reciprocal negative servitudes. If a land is subdivided into parcels under common development scheme with only parcels having negative servitudes, these restrictions may be impliedly binding against all subdivided parcels. It allows lot owners to enforce restrictions on the use of the property against other subdivisions. Lot owners enforce through injunction. Note, usually arises on exam where an owner divides land into smaller lots to create a common development scheme, subdivision, aka reciprocal negative easement or implied reciprocal servitude. Created through implication if 1, common scheme, the developer evidenced intent to create a negative servitude under a common scheme for all subdivided parcels. Common scheme may be evidenced through A, a recorded plat, B, general pattern of restrictions, and or C, oral representation to early buyers. 2, notice, owner of subject lot had notice of the restriction in the deed of other subdivision lots. Notice may be one of 3 types. A, actual. This is the literal knowledge of restriction. B, inquiry, neighborhood characters indicates a common restriction. Or C, record, chain of title for the owner's lot includes a prior deed containing a negative covenant or servitude.